Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in this video I'm going to talk about the 10 steps that you have to go through to navigate a debt collection lawsuit. You know, one of the biggest things that causes a lot of anxiety when you've been sued by a debt collector is just not knowing which way the case is going to go, not understanding the process. In this video I'm going to give you the overview, kind of the big picture of what it is that you're going through, how that can help you to navigate it to get it to where you want to go and get this thing resolved, and what each of those steps are. But if this is your first time here to my YouTube channel, please click subscribe, check that little bell. That way you'll be notified each and every week when I put out new videos that'll help you deal with your serious debt problem. All right, let's talk about defending debt collection lawsuits. So, you know, you get served with the summons and you immediately start to panic. You know, I get people all the time here in my law practice in Arizona who tell me they have visions of going to jail over this kind of thing and just not knowing what to do. And so sometimes they just get, you know, frozen and they don't do anything, which is the worst thing that you can do, is to not take action. So the first thing we're going to talk about is the complaint in the summons. Now, what a lot of people don't quite understand is that the complaint in the summons, the whole lawsuit process actually begins well before you know anything about it. The creditor, the plaintiff in the case, their job is to draft up the complaint in the summons and then they file it with the court. The summons actually has to be stamped by the clerk so that it's an official document where you're being summoned to court. And so they may do this, you know, even months before you actually become aware of it. It's because, like in Arizona where I practice, when they file the complaint with the court, if it's in Superior Court, they have 90 days to serve you. If it's in the Justice Court, they have 120 days to serve you. So it's entirely possible that this thing began 3-4 months before you even became aware of it. But that's the very first step, is that the creditor drafts the complaint and files it with the court. Now, the second step of the lawsuit is service. Like I just mentioned, the plaintiff or the creditor, they then have to take that complaint and summons. They have to hire a process server or use one of the constables from the local Justice Court and have them serve the complaint on you. Now, serving the complaint, as far as what constitutes service, there's a lot of confusion. And this may vary from state to state. If you're not in Arizona where I practice law, it could be a little bit different in your state. But in Arizona, they typically, the default position for service is they have to bring it by your home and literally put it in your hand. They also can leave it with someone who lives with you who looks to be of suitable age and discretion, is what the statute says. And so it is entirely possible, if I'm being sued, they could come by my house and leave it with my wife or leave it with my children, although I don't know if they're of suitable age and discretion. There's some argument there. But they could serve it with someone that lives with me. However, they can't serve it with someone who doesn't live with me. So if they come by your house and they serve your friend who's just there for a barbecue, that doesn't count. But if they do serve you or a family member or somebody who lives in the home, that does count. If they can't serve you, if they can't ever find you, if you're never home, if you're always at work or you work graves, whatever, that kind of thing, they can go to the court and ask for what's called an alternative service order, where they serve you through the mail and usually by taping a copy of the complaint and summons to your door. So if either of those things happen, you may want to really look a little bit deeper into what's exactly happening in the case to make sure that you are aware of whether you've actually been served or not. Now, the third step is an important one. It's filing a written response to the allegations in the complaint with the court. This document is called the answer in most jurisdictions, and you have a very limited amount of time to file an answer with the court. For example, in Arizona, you have 20 days from the day that they served you with the complaint and summons. That's why it's so important to understand when you were served, to write that down, put it on your calendar, put it in your phone, put an alert, whatever you need to do to make sure that you file your written response, your answer to the allegations with the court. If you don't do that, they're going to end up with the default judgment. That happens in over 95% of debt collection cases. People don't file an answer, they end up with the default judgment. There's usually attorney's fees and court costs, everything like that added on top of it, and the judgments just become out of control. Once they get that default judgment, they then are equipped to be able to garnish wages and bank accounts. So it's so vital, if you want to do anything right, to file the answer timely with the court. Fourth, after you file your answer with the court, the fourth thing that happens is disclosure. Now, you know, we've watched all of these old, you know, movies, Perry Mason, even new movies. You know, there's always a gotcha moment. A Few Good Men has the gotcha moment in it, where there's a surprise witness or some surprise documents or evidence or something that just blows the whole case up and makes it really exciting. In real life, it's not that exciting, mostly because of the disclosure rules. In all jurisdictions, federal, state, you're going going to have to provide some type of disclosure of what evidence, what your defenses are, what documents, what witnesses. Both parties are going to have to disclose that to the other. In Arizona, that happens 30 days after you file your answer with the court. The parties have to file what's called an initial disclosure statement, where all of that information is disclosed to the other party. If you don't disclose that information to the other party, then you may be barred from using it at a trial, which would be devastating to your case. You can also use this against the debt collector. If they try to introduce evidence that they've never disclosed before, you can object to it. So the fourth stage is disclosure, or sometimes it's called the initial disclosure period or the initial disclosure statement. The fifth step in a debt collection lawsuit is discovery. This is when written questions or requests for documents, written questions called interrogatories, something called requests for admissions, all of this together we call written discovery. You can send it over to them, they can send it over to you, and there's timelines when you have to respond to this request for information or documentation. Now, I have a whole other video, and I even have a tutorial, which I'll put a link to below this one, that talks about discovery from the defense point of view, because this is an area of the case that a lot of people who are defending a case, I think, kind of misunderstand. They think that their goal is to get as much documentation as possible from the plaintiff. However, you've got to remember that the plaintiff bears the burden of proof. They have to prove this case, not you. So the more documents they have, or the inverse of that, the less documentation that they have, the better it is for you. The sixth stage of the debt collection lawsuit process, in most jurisdictions there will be something called a pretrial conference. This is usually a relatively kind of administrative type hearing where information is provided to the court, and really the court becomes aware of your case for the first time. There may be discussions of settlement, or the court may just give you a trial date. They really just want to see, where's this at? Is this going to settle? Do you need a trial date? They may ask if you want to participate in mediation or like a settlement conference. All of that is discussed at the pretrial conference. Super important that you appear at this. If it gets set and you don't appear, in Arizona, and often the judgment is just entered against you automatically if you don't appear at the pretrial conference. So it's super important that you put that on your calendar, make sure that you appear. Whether the court's requiring you to appear in person or telephonically, doesn't matter, just make sure that you are there. All right, the seventh step in this, and this step could actually happen really at any time along the entire timeline of the case, and that's the filing of a motion for summary judgment. A motion for summary judgment is essentially a party's way of saying, Judge, we don't need a trial. Just look at our documents and tell us if we win. Now, usually, if you're being sued, most defendants do not file a motion for summary judgment just because generally it's not going to be granted. A creditor will file this in almost every single case. I have a tutorial and a template as well. I'll link those below, because they know this is one of the most difficult parts of the case for a self-represented person is responding to the motion for summary judgment. Essentially, like I said, the creditor will come in, they'll file a motion saying, Judge, just look at our documents, tell us if we win. You have then a time frame to respond to it. In most jurisdictions, it's 30 days. If you don't respond within 30 days, again, it's almost like a default. They're likely going to grant it, give them everything you're asked for, your case will be over, and you won't get a trial. This is a super important part of your whole case that you need to understand. Again, check out the links below for some additional detailed information and templates that I use when responding to summary judgment. All right, the eighth step is mediation, or sometimes it can be called a settlement conference. In some jurisdictions, they will require the parties to participate in mediation. This is where they assign a third-party mediator to the case to really kind of try to broker a deal between the parties to see if there's some middle ground that can be reached. Typically, mediation is done in person. The mediator will put the parties in two separate rooms, and then the mediator will go back and forth with different offers, counter-offers, and encourage the parties to settle the case. That being said, I know in this post-COVID world, I've actually done a number of mediations via Zoom lately. I don't think they're quite as effective, but the court may require you to participate in that, or the parties can request it if you think that it would be a good way to try and resolve the case. Step number 9 is showtime. It's trial. It's time to show for the case to go forward, for you to present your case either to a jury or to a judge and to put on your case. I'm not going to go into all the steps of a trial. Again, I'll put a link down below about some tutorials I have on how to present your case at trial, but the trial is the show. And you know what, again, you've got to appear, you've got to be ready, because Because if you aren't, it's not going to end well for you. You're going to end up with a judgment. And then the last, number 10, is depending on the result, either party can appeal. Now, it's important to know that if you decide you want to appeal your case, it's very time sensitive. So, for example, in Arizona, from the Superior Court, you have 30 days to file an appeal if you want the Court of Appeals to look at it. If you filed on day 31, you're done. You're out of here. It's not going to work. In the Justice Courts in Arizona, you have 14 days, 2 weeks, to file an appeal from the time that the judgment's filed or signed by the judge. If you don't do that, you're going to be barred forever from doing it. It's also something worth looking at as far as whether you should appeal. In most situations with an appeal from a judgment like this, the Court of Appeals or the appellate judge is going to look to see, did the trial judge abuse their discretion? It's generally not something where they come in and retry the case. It's something they're looking to see, did the judge get so far out of what's acceptable as far as a ruling that they need to reverse it? In a lot of cases, even if the appellate judge doesn't agree with what the final ruling was, unless it's really far out there, they just completely disregard the law. A lot of times they'll uphold those. So I hope that helps you to understand kind of what the typical flow of the debt collection process is, this lawsuit process that you're going through. Again, check the links below for some tutorials I put together that go into really a deep dive. If you're representing yourselves, these can be very helpful no matter what state you're in. If you're in the state of Arizona and you need help, give me a call. I do free consultations, and I'm happy to see how I can help you with your case. Thanks for watching today.